In June 2021, Jacob Zuma was convicted of contempt of the Constitutional Court and received a 15-month prison term. This verdict came after he disregarded the court's order to appear before the state capture inquiry and respond to questions unrelated to any specific crimes he may have committed. Throughout the contempt proceedings, Zuma abstained from participation and declined to offer any input regarding the potential consequences of his guilt. However, hardly 2 months into his imprisonment in July, he was granted medical parole. This decision came after Arthur Fraser, then the National Commissioner of Correctional Services, disregarded a recommendation from the Medical Parole Advisory Board, which deemed the former president ineligible for medical parole. The courts reversed Fraser's unlawful ruling, and on the morning of August 11th, prisoner Zuma reported to the Estcourt Correctional Centre. Yet, barely 2 hours later, he regained his freedom once more. It surfaced that the preceding day, President Cyril Ramaphosa had enacted a special remission order, enabling the release of purportedly non-violent offenders. The Electoral Court concluded that since Zuma lacked the capacity to appeal the sentence imposed on him by the highest court, it did not meet the definition of a sentence as outlined in Section 47(1)(e) of the Constitution. According to Section 47(1)(e) of the Constitution, individuals convicted of a crime and sentenced to over 12 months of imprisonment without the option of a fine are ineligible to serve in the National Assembly. However, the provision clarifies that a person cannot be considered convicted and sentenced until an appeal against the conviction or sentence has been decided, or until the time for an appeal has passed. This essentially means that the conviction and sentence do not become effective until the appeal process concludes, or if the convicted individual chooses not to appeal the conviction and/or sentence. In this instance, Zuma was deprived of precisely that. Zuma now contends that his entitlement to a fair trial was breached, since he was denied the opportunity to appeal. Citing a dissenting opinion penned by Justice Liana Theron in the contempt case, he asserts that this refusal of his appeal rights equated to being subjected to detention without trial. In a decision representing the majority of the Constitutional Court, Justice Sisi Kampepe dismissed this argument, highlighting that Zuma had been given ample opportunities to contest the contempt charges against him, but had failed to utilize them effectively. Legal commentator Nicole Fritz contended that Zuma's application for rescission essentially sought reconsideration and thus served a similar purpose to an appeal. Nevertheless, she noted that the nature of the offence of contempt of court, particularly when committed against the highest court in the country, precluded the possibility of an appeal. Moreover, a majority of the Electoral Court judges also determined that Ramaphosa's decision to grant a sentence remission to numerous inmates to alleviate prison overcrowding, thereby ensuring Zuma's immediate release after his return to prison due to the invalidity of his medical parole, effectively reduced his sentence to 3 months. This shorter term would render Zuma eligible to serve as a Member of Parliament. However, Judge Lebakang Modiba concluded that the constitutional authority vested in the President to grant pardons, reprieves, and remit sentences aligned with the concept that, while the President operated within the executive branch, distinct from the judiciary, the exercise of his power to remit sentences inevitably encroached upon the judiciary's sentencing authority. The IEC has since approached the Constitutional Court to appeal this ruling. This is because Fritz believes that the Constitutional Court would be unlikely to uphold Judge Modiba's majority decision from the Electoral Court, which determined that the sentence remission enabling Zuma to evade returning to prison effectively reduced his sentence from 15 months to 3. The Constitutional Court is now scheduled to hear the Electoral Commission of South Africa's challenge on May 10th. But now there is a problem. Zuma wants those Constitutional Court justices who sentenced him to 15 months imprisonment recused from deciding on his eligibility as a candidate in the upcoming election. In his affidavit, Zuma's attorney states that Zuma and, to some extent, the MK party, are of the firm view or reasonable apprehension that at least 6 of the justices of the Constitutional Court are tainted by bias and accordingly not fit to adjudicate this application. Zuma is targeting Justices Mbuyiseli Madlanga, Stephen Majied, Nonkosi Mlantla, Leona Theron, and Zukisa Chiki. If these justices were to recuse themselves, only 5 would remain on the bench to handle the case. And Section 162B mandates at least 8 Constitutional Court judges to preside over a case. In Zuma's view, these justices were part of the bench which, in his view, unjustly, although legally competently, sent him to jail for 15 months without the option of a fine or of complying with the relevant court order. If the corruption-accused former president and leader of the MK party achieves his goal, the Constitutional Court would fail to assemble the necessary quorum to address the issue.